For the record, this continuation state of Tennessee versus Tremaine Wilbourn, docket number 1600515. I'm sure we haven't found Mr. Wilbourn guilty of first-degree murder. Court will proceed with a sentencing hearing. Ms. Gangley, you want to put something on the record before we start the sentencing hearing?
I do, Your Honor.
Yes, sir, you may proceed.
Your Honor, there's been a tentative offer should Mr. Wilbourn accept a life without parole. It would involve waiver of the direct appeal in this case and the withdrawal of the appeal in the federal case. Mr. Wilbourn discussed that with his grandmother as well as and if we could please get a final decision on the stand by the board, Your Honor.
Yes, sir. Mr. Wilbourn. Come forward, please, sir.
See, how long you going to stand, sir?
What's up, Mr. Wilbourn? I can't hear you, sir. Mr. Wilbourn, if you don't want to take the witness stand, that's fine. But Ms. Gangley needs to ask some questions of you. You understand that, sir? You can stand up, please, and raise your right hand, please. Raise your right hand, please. Do you solemnly swear or affirm to tell the truth, self you done? Thank you, sir. Ms. Wilbourn, you put your hand down if you want to. You may sit, you can remain standing, but you have to put your oath so Ms. Gangley can ask those questions of you. Ms. Gangley, you may proceed.
Wilbourn, during the break, I told you about a potential offer. Is that right? That potential offer is life without the possibility of parole. Is that right? Someone would sign paperwork and get a stay, and initial conviction stay. Is that right? And that involves withdrawing or waiving rather than legal activity on this case. Is that right? It also involves withdrawing on the federal case. Is that right? You talk to your grandmother, is that right? And some of the witches. You also talk to Alan. You talk to this Haley and this Hall, is that right? And I talked to you as well, is that right? All of us encourage you to accept life without parole, is that right? You want to accept life without parole, or you want to be sentenced here? The sentencing hearing is where the state would ask the jury to vote for death penalty on one. Right, they would show the jury some aggravating factors, specifically that you've been convicted of bank robbery and using a firearm in the commission of bank robbery. That the murder was committed for the purpose of avoiding or interfering with prosecution or lawful arrest. And number three, the murder was committed against a law enforcement officer. And you understand we would show the jury several mitigating factors when we had to ask the jury to spare your life. So with that in mind, you want to accept life without parole, or you want to continue with the sentencing hearing?
I'm sorry, Mr. Wilbourn, what's the answer, sir? Wilbourn, we should have started sentencing hearing 30 minutes ago. You asked me to give you permission to talk to your grandmother, which I've done so. I do need an answer because I cannot just say, Mr. Wilbourn, take all the time you need. We are in the middle of the trial. The state has made this offer. You've had time to talk to your grandmother for hours or days at a time. You don't have to accept the state's offer. You told before trial that you wanted the trial, that you not take the state's offer of life in prison. The state has not made an offer of life in prison without the possibility of parole. If you want to accept that offer, you may do so. If not, the state will present proof as to why the jury should find that there are certain statutory aggravating circumstances. Mr. Gangle has indicated to me those circumstances would be that you have prior felon convictions involving use or attempted use of violence. Statutory elements rather involve violence to a person, that you also killed a police officer, and that the murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution. The state presents that. They can also present what's called victim impact statement is not an aggravating circumstance, and the court will tell the jury that they can consider an aggravating, consider victim impact for a limited use, but not as an aggravating circumstance. And Mr. Gangle, this past in this hall, will present what's called mitigation. And again, what I told to the jury on Monday and Tuesday, that mitigations are reasons why Mr. Ganguly and Ms. Hall and Ms. Pastor believe that a jury should not sentence you to the death penalty. The jury does not find that there are statutory aggravating circumstances beyond a reasonable doubt, the jury will sentence you to life in prison. If they find that there are certain statutory aggravating circumstances and find that it's not outweighing mitigation beyond a reasonable doubt, then the jury will sentence you to either life in prison or life in prison without the possibility of parole. But the jury finds Mr. Wilbourn that the state has proven the existence of one or more statutory aggravating circumstance or circumstances beyond a reasonable doubt, and it outweighs any mitigation beyond a reasonable doubt, the jury will in fact sentence you to the death penalty. So that's what Mr. Gangle is asking right now. The state is making an offer of life without the possibility of parole with certain conditions, that you withdraw this appeal and that you withdraw a parallel appeal in federal court, and the state will offer life without the possibility of parole. Otherwise, they're going to proceed with a sentencing hearing, and that's the jury to sentence you to the death penalty, Mr. Wilbourn. You understand that, sir? What do you not understand? Mr. Wilbourn, I have no input into anything that's been discussed, sir. I'm just telling you what the boards have apparently discussed, and that's the state's offer. You understand that, Mr. Wilbourn? What do you want to do in this case, Mr. Wilbourn? Mr. Wilbourn, is this your decision, sir? Is this your decision? Has anybody threatened you, promised anything, put any force or pressure on you in order to make this decision, sir? Ms. Wilbourn, do you understand you have a right to have this sentence here on a jury that has convicted you is still present? You have a right to have a sentence here, and the state have to present that proof. The state had indicated before the lunch break they had 4 witnesses that they wanted to present. They will probably present proof as to what the circumstances are of those valid felony convictions, and that's one of the statutory aggravating circumstances that you were previously convicted of one or more felonies other than the case that the jury has found you guilty of, the statutory elements of which involve the use of violence to a person, and the state was relying on the offenses of armed bank robbery and perhaps one other federal case. The state would have to present that proof. They have to present proof to the court in hearing outside of the presence of the jury, so the court can make determinations of whether or not the statutory elements in fact involve violence to a person. They will also present victim impacts evidence that would also be presented outside the presence of the jury, and I have to make a decision as to whether or not the jury will hear that. If I make that decision and present that proof, they'll also present proof that Sean Bolton was a police officer that his murder was committed for the purpose of avoiding, interfering with, or preventing an unlawful arrest. And Mr. Gangle, this pastor was called, will present mitigation. Now, when you tell the Judge Cochran taking the life without the possibility of parole, you are waiving a formal hearing before a jury to have the jury make a decision as to what your punishment should be. And again, the jury can sentence you to life. It can sentence you to life without the possibility of parole, or the jury can sentence you to the death penalty, Mr. Wilbourn. There are 2 instances in which the jury can sentence you to life. one, if the jury found that the state had not proved the existence of one or more aggravating circumstance, statutory aggravating circumstance, if they found the state has not proved that, this jury will sentence you to life. If the jury found the state had proved the existence of one or more statutory aggravating circumstances and found that it did not outweigh mitigation, and Mr. Gangoul has filed a notice of what he intends to ask the jury to consider mitigation in this case. If the jury found that the aggravating circumstances did not outweigh mitigation, then the jury has a choice. Mr. Wilbourn can sentence you to life in prison for life without the possibility of parole. But if the jury finds that the state has proved the existence of one or more, 1, 2, or 3 of those statutory aggravating circumstances the state of Tennessee is relying on, and that Mr. Wilbourn, the jury's verdict would have to be the death penalty. They could not make a decision at that point. They would have to sentence you to death. If I sentence Judge Coffey, I'm taking your life without the possibility of parole. You're waiving your rights to continue with that sentencing hearing. Do you understand that, sir? You're waiving your rights to have your lawyers present mitigating evidence that could convince the jury to sentence you to life in prison rather than life without parole or the death penalty. Do you understand that? And again, is this your decision, sir? Has anybody pressured you, promised anything, put in force or pressure on you in order to get you to make that decision, Mr. Wilbourn? Mr. Tremaine Wilbourn, I'm going to find for the record that your attorneys, Mr. Julie Gangoul, Ms. Lauren Pasley, Ms. Lori Hall, and this court have advised you to have a right to continue with the sentencing hearing, that you have a right to have your lawyers present mitigation evidence to contradict any aggravating circumstances that the state might present at sentencing, and that you waive that right intelligently, knowingly, and voluntarily, and the lawyers will draw up the appropriate judgment on this case, Mr. Wilbourn, and will proceed with sentencing without the benefit of the jury. I will sentence you to life in prison without the possibility of parole as indicated or as agreed upon, and this will terminate your trial. It will be over with once that judgment is entered. Do you understand that, sir? Do you have any question when I ask the court right now, Mr. Wilbourn? Mr. Wilbourn, that should happen in a few minutes, sir. As soon as Mr. Gangoul will have you sign the paperwork, sir. Any other questions, sir? He's indicated no for the record. You may call the court into recess. Everyone can remain seated, and as soon as those documents are prepared, we'll proceed with the sentencing on this case without the benefit of a jury, as Mr. Wilbourn has waived his rights to proceed with jury sentencing on this case and has agreed to accept an offer that the state of Tennessee has made, and will proceed that sentencing as soon as the paperwork is ready.
Court stands in recess. Court come to order, remain seated.
Mr. Henderson, Ms. Bird, the second, third, and fourth counsel, which Mr. Wilbourn is being convicted. Are there any agreements or recommendations on those counts that we need a sentencing hearing for counts 2, 3, and 4?
We will talk through the cases we can agree upon the
Yes, ma'am. We call it according to recess, or work remain seated.
Court stands in recess.